been there as the National Cybersecurity Coordinator for past 5 years, and we've got multiple opportunities to work with him. So I thank General Pant for finding time over a weekend for joining us today. Uh, and then post General Pant's address, we will have a session by Mr. Rakesh Maheshwari highlighting what the industry should be doing for implementing the Personal Data Protection Bill. General Pant, thank you. Over to you.
Thank you, Kanishk, and good morning to all the attendees, physical and virtual, of this very timely and relevant event. And my compliments to the India Future Foundation as well as the USI for hosting and organizing this. At the outset, let me state that it's been a very historic week in the judicial evolution of our nation. First, of course, the long journey from Justice Puttaswamy to the Shri Krishna Committee to the Chris Gopalakrishnan Committee to then all the amendments and the new draft that went around. That journey has finally come to an end with the assent of the respected President of India after it was passed by both the houses. And the Digital Personal Data Protection Act of 2023 is now finally it has seen the light of day. I cannot proceed without also mentioning the second major event that has happened in the judicial journey of our nation, which has been the massive overhaul of the criminal laws in India as presented to the Parliament. And as you have all been reading about it, that the 163-year-old Indian Penal Code has been replaced with the Bharatiya Nyaya Sanhita 2023. The 50-year-old Criminal Procedure Code has been replaced with the Nagrik Suraksha Sanhita 2023, and the 150-year-old Indian Evidence Act is being replaced with the Bharatiya Sakshya Bill 2023. Of course, all these three have been sent to the Standing Committee. The approval has not taken place as yet. But if you recall, this is how we went about our DPDP bill also. Initially, there was a standing committee, the JPC of the Parliament, under Shri Tharoor, then under not Shri Tharoor, Miss Lekha was there, then Mr. Chaudhary took over the JPC. So it's been a journey. So as I said, a historic week in the judicial journey of our nation. So let us now focus on the DPDP. A lot has already been said by Honorable Minister Vaishnav and Minister Rajiv Chandrasekhar on this. And I must say that if you see and read and hear both these ministers, the clarity that they have got comes out very loud and clear. You can see the video in Twitter of Minister Chandrasekhar also, how he's explained the bill. So it's so nice to see that at the helm of affairs, we have these two stalwarts who are guiding our nation. So as I said, the story started in 2017 when after the Justice Puttaswamy case, privacy was declared as a fundamental right under Article 21 of the Constitution. And since privacy includes your personal data, and we are now talking of your digital personal data, this particular bill that we are discussing aims to safeguard the digital personal data of 140 crore Indians. The draft was very well vetted by a large number of organizations. In fact, 48 organizations and 39 ministries vetted this draft. And fortunately, we have Shri Rakesh Maheshwari with us, who was, one of those who actually helped in drafting the bill. So you are all aware, it's there in the public domain, that the bill has been divided into 9 chapters. Very logically structured chapterization has been done. First, of course, gives out the definition. Second, gives out the obligations of the data fiduciary. Then third, gives us the rights and duties of the data principal. The 4th chapter talks about the special powers, the processing data outside India and the exemptions, etc. The 5th chapter talks about the Data Protection Board of India, which will be constituted in due course with a chairperson and various members. Of course, one of them has to be a law qualified person. And then the 6th chapter gives out the powers, the functions, and the procedures to be followed by the DPBI, if I may call that board, the Data Protection Board of India. The seventh, of course, is the appeal and alternate dispute resolution. Eighth is the penalty and the adjudication. And finally, we have some miscellaneous aspect of laying down rules and amendments, etc. So a very well-structured bill, which I am sure will be expanded by Mr. Rakesh Maheshwari. And please keep your questions for him. As I said, he's the brains behind it. So with that, let me not take much time, but again, compliments to India Future Foundation and the USI for organizing, as I said, this very timely and relevant event. The first mover advantage is there with the IFF. So it's back to you, Kanishk. Thank you very much for giving me this honor.
Thank you, General Pant, for highlighting this so wonderfully, and thank you for the role that you have played in ensuring we have a safer internet in India. The work which you have done as a national cybersecurity coordinator holds immense importance for all of us as we see more steps being taken to safeguard the digital knowledge. Uh, I'll now invite Mr. Rakesh Maheshwari to walk us through what are some of the key areas which the bill talks about, how the industry would look at complying to this data protection bill, what are some of the key steps. So as technology professionals or as public policy or law professionals, if we have to look at getting our journey right, getting the companies to comply to the data protection bill, what are some of the key steps that we need to look into? Rakesh Maheshwari ji, over to you.
So thank you, General Pant, and thank you, Kanishk ji, to introduce me so nicely. And yeah, it puts, in fact, even more onus on me, more responsibility on me to be able to prove my credentials in respect of communicating the intent, content, and maybe any other clarifications that you may have on the new Digital Personal Data Protection Act. It's no longer a bill, and hence now onwards, and maybe throughout my slides, it will be referred as either the complete Digital Personal Data Protection Act or DP Act, or simply the Act. So that's how it is. Presidential assent has already been received yesterday, and it's a matter of time when the bill or its various sections, the effective date of getting operationalization begins. In fact, if you have any questions, you can put it on the chat box or in the question answer box. And as of today, I mean, as of now, I'm not really able to see, and I will not be able to see your questions. And therefore, I request the IFF team to take up those questions whenever you feel like. We can easily, I mean, take a, in fact, have a look at those questions rather than simply having a monologue. Having said so, let me start with what this act is all about. So normally, I mean, it's not that India is the first, and in fact, there are about 100 countries which have already got legislations around the personal data protection laws. And most of these protection laws, because it's about personal data, therefore, they are centered around the person, they are centered around the individual, which in most jurisdictions have been stated to be data subject. In the Indian context, in the DPDP Act, there is a paradigm shift of this thinking, and this individual, this data subject, is being or has been named as data principal, thereby conveying that you are the boss. You are the person, I mean, whose personal data is important, and you are actually owning the data. Similarly, the entity which is collecting, entity which is processing, or entity which therefore is doing something with this data, which normally has been called as data controller, in the Indian context is the data fiduciary. Here also, the intent is very clear that you are not the controller, but you are just a fiduciary. You are just a custodian of the data. And hence, it is the right which are more important than, of course, the ownership. And you are just entitled to do whatever is supposed to be lawful with respect to this debt. So therefore, any law for that reason is having two clear entities. One side it's individual, the other side it's the organizations which are collecting the data, and it's all about the rights of the individuals and the responsibility and accountability of the platforms, the organizations, to be able to process this data. This is all, I mean, all the acts talk about it, all the laws across the jurisdictions talk about, and so is the DPDP Act 2023. General Pantji has already conveyed about the history. Of course, it's already known. I'll just like to mention that till such time the Act comes into operation, the existing IT Act and its provisions, particularly with reference to Section 43A and the SPDI Rules 2011, which are supposed to be withdrawn once the Act comes into force, shall continue to be valid. That means, as of today, what is the arrangement? It is the Section 43A of the IT Act and the SPDI rules which are valid. In time to come, as Data Protection Board comes into existence, the law comes into full force, the Section 43A and the SPDI rules shall stand omitted and hence withdrawn. Rest of the things have already been conveyed, so I'm just skipping. The bill, sorry, the act is the act, the way Indian government has developed it, not only, of course, revolves around the rights to the individuals, but is also supposed to be business friendly. It is supposed to be an act which provides opportunities for innovation and investments. And therefore, as we move ahead, you will see that it makes an appropriate and right balance between the user rights and the lawful processing of the data, and some bit of flexibility, in fact a lot of flexibility, with no criminal penalties, and even the civil side penalties have been kept at much lower values, and I mean vis-a-vis the other jurisdictions. And the way the whole procedure has been developed is also a very modern one, is also a complete online one, and to that an extent it's a modern law, it's a simple law. In fact, if you have gone through the text, it's very simple to comprehend, it's very simple to understand, and to that an extent it's one of those laws, I mean, in the country where the word provided, for example, has not been used. So those of you with the legal background, or those of you who have read through the laws, acts, various acts, will realize that normally provided is something, I mean, even in our IT rules, IT intermediary guidelines and digital media ethics code, because that's the latest rule from the IT Act, which has, I mean, been in operation since 2021 and has undergone certain amendments. One of the most actively used rule. There are lots of provisions there also, but not in this law. Comes the first question, whether as an organization, now I'm looking at it from an organizational perspective, I'm looking at it from a citizen user perspective, the data processor and data fiduciary perspective. Does it apply to us? In case you are using, you are processing, you are collecting, you are indexing, you are organizing, you are doing something with the data which is in digital form, or which was collected in physical form but has been digitized subsequently. So the net crux is, as long as it is digital, the law is applicable. as long as it is about goods and services being offered to individuals within India, wherever you are, organization, it is applicable. So that the bill, therefore, the act is extraterritorial in nature. It's applicable to both the private and the public entities. Of course, in respect of certain public entities, there is a specific provision for notification for exemption of certain public entities. So unless you have been exempted, the bill equally applies. And to the extent you have been exempted, the bill equally applies to the private and the public entities operating. Of course, public entities have to operate from India, and private entities can be operating from anywhere, but as long as you are processing the data of Indian users. However, the caveat now is that the bill is not applicable to processing for personal or domestic purposes. So one-to-one, if we want to have communication, we are giving consents, we are sharing photographs, we are sharing data, the bill is not really applicable. And certain data which you have publicly put on, you have decided to put in public place. For example, let's say on social media, you have put certain data, or maybe on certain websites, you have put certain data about you. The bill, the act is not really applicable. So that data which is publicly available or has been made publicly available by you means as the Indian citizen, as the data principle in the context of this act. There are certain key terms which I think are important to be understood. Personal data, I hope everybody knows, but equally important is it's not just about it's about the individual. So if it is about entity, it's not personal data. So any data which can identify you or which is related to you is what is personal data. Now related to you, therefore, maybe a given IP address on a particular time, if it is related to you, it will qualify in the definition of personal data. Data principle I have already talked about, the person whose data is being talked about. Data fiduciary is the
रिकॉर्ड
organization.
करना है
Can I
ये
request
जो बोल
everyone?
रहा है इनको रिकॉर्ड करना है कैसे होगा
Can we have everyone
बताना
please mute? Yeah, please go ahead.
Data fiduciary is that entity which is collecting the data, which decides the purpose and the means of processing. I can take up a small example.
Sir, it's
Maybe-
not audible.
It's audible for us. Thank you.
Yeah,
we can
it's
hear
audible
you.
for us, I
Yeah,
think.
yeah,
We
audible
can
for
hear
us actually.
Yeah,
Audible.
all of us.
Please.
It is audible.
Please put it on the chat window. I don't want him to, get disturbed during the conversation. We'll fix up the audio from behind. Yeah. Thank you. Mr. Maheshwari, over to you.
Yeah, so is in certain scenarios, for example, it's possible that an organization has a front end being managed through let's say a call center, or let's say through some representatives. So those representatives, that call center is actually working on behalf of the organization. So in such a scenario, it is the organization which is the data fiduciary and not the front end or organization which may be working on behalf of the main organization. In fact, the front end which is there, or in many cases the back end which is there, which further processes the data, collects the data from the data fiduciary and processes it the way the data fiduciary likes it, then that organization is called as data processor. And we can take up certain examples to be able to clear this point. And processing is also a broad word which has been used. It is not about the processing as we understand in English. It's about processing includes data collection to data, doing something with the data, to finally maybe storage, to finally close the data, dispose the data, erase the data. So data processing is set of all those activities, is one or more of those activities, starting from creation of data till the disposal of the data, complete disposal of the data. And lastly, it is the definition of the child or children, which in the Indian context is 18 years and below. And this definition has been taken, from the other laws, and therefore it is uniform across the country with respect to the definition of the child. The personal data can be internal to the person, can be external to the person, can be about historical, can be about financial, can be about social status of the person, can be about the computer device, can be about your context, can be about your location. So this slide just gives you a view, a words overview of what possible. What is that we are talking about? What is that we want to secure? What is that we want to regulate? Certain examples of data fiduciaries. Banks, for example, hospitals, social media platforms, sub-registrar's office for property registration. These are some of the examples I have written. I definitely not the exhaustive list. Just wanted to also give my opinion with respect to law enforcement agencies. So it's possible in some scenarios where the law enforcement agencies, for example, directly collect the data from for example, possible convicts, prisoners, or maybe accused. So information which they collect directly, they are the data fiduciaries. However, let's say an FIR has been filed, and as part of the investigation, they are looking for certain information being collected from, let's say, from a social media platform. Now, when this information is being collected from a social media platform, because privacy is a fundamental right, it's not an absolute right. And law enforcement agencies, certain or maybe certain cybersecurity agencies, in certain cases, can seek for this data, which is well within the exemptions provided beyond the fundamental rights in the Constitution. So if such data is being sought from a data fiduciary, in such a case, the same law enforcement agency will be qualified or will be called as data processor and not as a data fiduciary. So an organization can be a data fiduciary also, can be a data processor also. Let's say an e-commerce platform. An e-commerce platform is also collecting data, is collecting a lot of personal data, but it may also be processing it in terms of maybe doing analysis of what's the preferences in a particular area, in a particular age group, maybe in respect of certain amounts of payment for certain kind of products which are being sold. So they become a processor also. So they are a data fiduciary and they are significantly a data processor as well. Of course, they may outsource it. This outsourced agency will also be qualifying as a data processor. CAF, customer acquisition forms. Customer acquisition forms as being done by the ISPs or TSPs. So once again, the shop may be actually the one where finally it is being collected, but the shop is not the data fiduciary. Shop is just a representative. Data fiduciary is the ISP or the TSP, as the case may be. The license. So on and so forth. I'm just moving on. Sometimes, in fact, I was talking yesterday whether employer relationship, whether the employee should be called as a data processor. This question, therefore, I pose it to you, and maybe we'll discuss it later on as to what the answer. Or can a vendor in an e-commerce platform be also treated as a data principal? So this question also I pose it to you and keep it for discussion later on. Certain principles on which the PDP Act, and this is something, when General Pantji was talking about the two ministers from the mighty have been very active on the social media. One of the very fond slide of both these ministers is about the principles on which the whole act is being there. These principles have not been explicitly stated in the Act, and therefore they are available only to privileged people, I mean, or to the ministers. Of course, with these seminars, these principles also get conveyed. Principles of lawful, fair, transparent, transparent use of personal data, and per se they are all embedded into the Act. Principle of purpose limitation: collect only what you think is legally allowed. I mean, what is lawful, and what is lawful is actually what is not legally impermissible is lawful. So it's the other way the definition has been used. Collect only minimum. Collect data with a clear explanation as to why it is required. Collect data or process data to the extent and only for such duration, which is the bare minimum, considered bare minimum. Ensure that while the data is being there with you, have reasonable safeguards, and there is a principle of accountability. Whoever has collected has to is accountable for the security of this data, is accountable for integrity and completeness of this data. The Act, in addition to being simple and not having any proviso, also uses the word she or her instead of he or him, which normally all the acts based on a General Principle Act of 1897. I mean, that's the convention which is being used across the legislations developed in India. A stiff resistance from the Department of Legal Affairs, but finally agreeing to the word she or her being used, which includes now he and him. I move on to the structure. So broad structure, General Pant also talked about of the various chapters, the way the whole Act is organized. Chapter 1, which is preliminary, talks about title, commencement, definitions, and applicability of the Act, which is what I have already covered. Chapter 2 is about obligations of data fiduciaries. And here, when I talk of data fiduciaries, there are three categories of data fiduciaries which have been talked about. So one is the data fiduciary itself, the general class of data fiduciaries. So everybody who is collecting data, who is processing data with a purpose, will be called as data fiduciary. And the way we, for example, had mentioned in the case of IT rules, we introduced the concept of significant social media intermediaries. So significant word has also been used in the context of data fiduciaries as well. By the way, the data fiduciary here can be a body corporate, can be a government entity, can be an intermediary. So they may be, I mean, conveyed by different words, but in the context of Digital Personal Data Protection Act, they will be either called as data fiduciaries or data processors, as the case may be. So one, the general category of data fiduciary, and if you are large enough, if you are dealing with certain strategic data, if you are dealing with maybe some data which has a potential to impact sovereignty and integrity of the country or security of the country, or maybe can provide or can cause significant harm if the integrity of the data is lost or maybe data is leaked. So in such cases, and for such organizations, for such data fiduciaries, they will be called as significant data fiduciaries. The whole purpose is that you create obligations for the data fiduciaries and you create additional obligations for significant data fiduciaries. I mentioned that the Act is actually business friendly. So where exactly it becomes business friendly? Yes, if you are small enough, if you are not a large organization, or if you are clearly a startup as has been declared by Ministry of Industry Promotion, so DPIIT, hopefully as of today, then, or maybe MSME, whichever ministry is dealing with defining the startups per se have been clearly designated as the class of data fiduciaries which will have minimum liability in the act. So some organizations which have minimum, some organizations which have general, and some organizations which have additional obligations. Now, when I say additional obligations, the additional obligations, so first of all, let's talk of general obligations. What do you think should be the general obligations? So every organization for that reason, every data fiduciary for that reason will have to present a clearly in simple language a notice to the data principal while through which they communicate their intent to collect or to take consent of on the personal data which is being collected and which is being processed by the data fiduciary. Now, this notice has to be given in English or in one of those languages which are there in the 8th schedule of the Constitution, option for which will be the liberty of the data principal who is supposed to be giving the consent. Now, this may create a huge burden on the data fiduciary, and I do believe, I mean, there used to be an explanation in the version which was released in November 2022. There is no explanation now. I do believe, therefore, whichever languages the platform supports are the languages which the notice should also be able to support. But if you are only supporting English but want to do business in India, maybe it is expected that you select at least one more language, one more Indian language. So this is the notice which every data fiduciary will have to give. Every data fiduciary will also have the obligation of maybe providing the personal data details, the details of the organization where this data is being shared, the provision to be able to update and correct the data of the citizen as and when they are asking, as and when she is asking, the ability to erase the data as and when once again there is a request from the data principal, and if there is any grievance from the data principal, the data fiduciary should be able to redress the grievance in a reasonable time. So it is expected that every data fiduciary will provide a detail of their grievance officer. What are the additional obligations of the significant data fiduciary? A significant data fiduciary will also, in addition to the general obligations, will also have to have a data protection officer, an India-based data protection officer. And as soon as I say India-based data protection officer, it means you also have to have an office here in India. You also need to have independent auditors who will be then able to carry out independent auditing of the processes, of the practices of this significant data fiduciary. And they will also have to carry out data protection impact assessment, which is also has to be a periodic activity. So these are certain additional activities which a significant data fiduciary will have to carry out. And with respect to the smaller ones, there are certain obligations, for example, certain obligations which have been removed. Of course, everybody has to give the notice, but the requirement of data erasure has been removed from there. Everybody, of course, also has to be, and there are some others. I mean, it's a question of going into the details. I am not right now going into the details, but I am just conveying it from a broad perspective. Rest is a matter of English, I mean, which you and me can always read. I am also not from a legal background. So the requirement of maybe the grievance, the requirement of particularly erasure of data are very, very diluted in case of the smaller data fiduciaries. We come to the data principal. So chapter 3 deals with rights and duties of data principle. Yeah, before we move into obligations, in terms of obligations, it is also the obligations to ensure security of this data which has been collected and which is being processed by the data fiduciary. Reasonable security safeguards are expected. It is your responsibility as the data fiduciary to prevent data breach. It is your responsibility as the data fiduciary to ensure organizational and technical controls to be able to comply with the requirements of this act. In case there is a data breach, it is also an obligation on the data fiduciary to report it to Data Protection Board, which is what I will be subsequently talking about, but also to inform the data principal whose data has been breached, maybe unintentionally, maybe intentionally, whatever it is your obligation to report it to bring it to the knowledge of data principals as well. I move to the next, which is about the rights of, in fact, indirectly, I have already touched upon the rights of the data principal. So right to access information about the personal data, right to correction and erasure of personal data, right to grievance redressal, and right to nominate. So while you are still alive, you want to maybe pass on your rights to someone. It's like writing a will, and which is what is possible. Of course, from this data principle, it is also expected that she, now I'm very categorically mentioning, she provides the data correctly, completely. It does not impersonate. So if there is any mischief being done by the data principle, thereby causing an unnecessary friction in the system, and maybe taking the data fiduciary to the Data Protection Board for penalties,